Good afternoon. My name is Giuseppe Nesi. I'm the Dean of the Law School here in the University of Trento. I'm very glad to be here. I hope there will be more attendance, maybe during the afternoon. Although, as you may know, Roberto Toniatti, who is the organizer of this event, is seriously sick. I think that he got something during his journey to India, as far as I understood. So we are going to reshape the whole afternoon. Marco, Dani will give you all the necessary informations. I will confine myself to welcome you all here in Trento. I see also many friendly faces around, and I welcome them, of course, very, very warmly. And also those who are here for the first time, you will surely enjoy this wonderful place and atmosphere that is very conducive to reflection and to study. You are going to develop a topic that has been for several years one of the main issues studied by our colleague, constitutional lawyers and comparative constitutional public lawyers, which is the supranational, exactly the perspective of the supranational judiciary. In this word where we hear quite frequently references to the fragmentation of law, I think that the idea of the supranational judiciary is something that could appear quite appealing. Frankly speaking, being an international lawyer, you know that we, as international lawyers, refer quite often to issues such as fragmentation. I don't think, personally, that this is one of the serious risks that we face, even in today very fragmented world. Maybe because of my of the studies of my youth, I would say, I tried always to follow certain ideas and in studying law, and these ideas led me to have a system, to have a legal system in my mind. Many people think that being an international lawyer, of course, I am just joking. This is not the case, in my opinion, and I think that those who know me understand very well what I'm referring to, because if you have a good education, a good legal education, legal order is legal order. It can be the internal legal order, the international legal order, the legal order of an international organization, but the legal order is the legal order. So in this regard, I always doubt that notwithstanding many attempts to crush or to fragment the law, this idea of fragmentation can be successful. In this regard, I'm sure that the existence of the idea of a judiciary that puts some order in legal matters can be extremely helpful. I don't want, of course, to go in depth. I maybe will come back later because I have also to see my students today later. But I would like very much to be here, so I will, from time to time, I will appear. And I give the floor now to Marco, who is going to explain us many things concerning today and tomorrow's event. Thank you.
Thank you. And good afternoon to all of you. So many of you already know that I am in the uncomfortable position today of wearing a hat I didn't expect to wear, which is the hat of Roberto Toniatti, who unfortunately is ill today. I cannot take part to at least to the first day of the conference. What I will try to do, and I probably be unsuccessful in this because I'm not, I don't even try to take the position that, or to play the role that Roberto was supposed to play today, is to, in a few words, explain how this conference is situated in a larger research project which is coming to an end exactly in 2015. And then to say a few introductory words on the conference. So the conference of today is a conference which is located in a broader research project entitled Jurisdiction and Pluralism, and whose main idea is basically to study all the varieties of legal pluralism we are witnessing in an ever more complex legal space, and to study them from the standpoint of the judiciary. And therefore, in the last years, we had several conferences in this faculty, but in other Italian universities, in which the issue of legal pluralism was studied by looking at how courts are able to mediate the conflicts which are inherent in a varieties of pluralist context, such as, for instance, religious pluralism, territorial pluralism, normative pluralism. And today we arrive at a certain type of pluralism, the pluralism which has emerged in the European legal space, a pluralism which is made essentially of the relationship between the national constitutional orders, the legal order of the European Union, and to some extent the legal order of the Council of Europe, and essentially the Court of Strasbourg and the ECHR. What we are trying to do with this conference is to provide a nation and to test whether it is possible, a notion, sorry, and to test whether it is possible to speak from a theoretical point of view of a supranational judiciary, understood as the legal system enforcing European Union law. As probably you know, European Union law has, of course, its judicial apparatus, but it is a judicial apparatus that relies very much on the working of national courts, which are coordinated with the Court of Justice, and with a number of other courts which are related to the working of this judicial system. With Roberto and Raffaele Bifulco, who has helped to organize this conference, we have decided to structure this conference in 3 sessions. The first session tried to map out the supranational judiciary from an organizational point of view. And so the first perspective which is studied is the organizational one, and we will see how the supranational judiciary is structured. Probably if Roberto will be able to attend tomorrow, he will give what was supposed to be the overarching paper for this session. And then we will have a contribution by Simone Benvenuti on how the supranational judiciary is structured in the area of freedom, security, and justice, by Raffaele Sabato on the organization, recruitment, and training and networking in the supranational judiciary, and Mathias Hartwig will study the difficult interface between the European Union legal system and the ECHR. And tomorrow we'll have other 2 sessions, a comparative one, which we will try to identify the peculiar characteristics of the supranational judiciary with a view to other comparable, we think, or judicial organizations, such as the one of the Inter-American Court of Human Rights, the one of the European Court of Human Rights, and the organization of the judicial power within federal constitutional system. And finally, the last session, tomorrow afternoon, we'll try to qualify and to understand the supranational judiciary from a normative perspective. So it probably is going to be a more theoretical session, although it will be substantiated with the rich body of case law which is emerging, especially in the recent years, as a consequence of the economic and financial crisis. So we had to restructure a bit the program, and the idea is the following. We will have first the keynote address by Professor Carlo Guarneri, who will introduce our work by talking about the supranational judiciary and the quest for a common European judicial culture. And afterward, we will have another opening remarks rather than the concluding by Professor Miguel Maduro, who joined our work. He was supposed to sum up and to conclude our conference, but unfortunately he cannot be here for the whole conference, and therefore he will anticipate his talk today. After these two opening remarks, we will have the coffee break, and after the coffee break, we will have the first session. But now I think we can really start with Professor Carlo Guarneri. My thanks to him for coming and to accept our invitation. And please, the floor is yours.
Thank you very much. Thank you very much. Thank you, the Faculty of Law of the University of Trento. Thank you to Professor Nesi, to Professor Dani for the invitation. Thank you also to Roberto, who is not here. I will thank him tomorrow, maybe, I hope. And I hope my address will be a key, and that will be useful to clarify the subject more than to confuse it. Anyway, when Roberto asked me to intervene in this meeting, I was a bit perplexed because I'm not a lawyer, and so maybe I'm not so much conversant on legal matters. However, he assigned me, the title of my intervention, and so I see judicial culture. And so, oh, well, there is a culture, and so I can say something about culture from a sociological point of view, of course. And so I will try to focus my intervention on the quest for a common European judicial culture. This is a problem, actually, I will try to deal, and I will try to provide also a kind of framework in order to understand the development of this culture. And first of all, I have to remind you of something maybe very obvious, of the fact that actually, national and actually supranational courts, the supranational judiciary, play an important role in the implementation of the European Union public policies and in general in the building of the European Union. So this is just to support this very banal statement with a good quotation. I quote one of the most important political scientists on the subject, Martin Shapiro. Martin Shapiro actually just a few years ago stated that, the European Court of Justice is the most successful new constitutional review court. And so much of its success, of course, has been made by the referral procedure and by the role played by the national courts in feeding cases to the European Court of Justice. And of course, this role is going to be always very important, even in the immediate future, and this is something I don't think I have to deal very much of. Why courts have played a so important role in the European Union? And I think from an empirical point of view, there are some remarks to be put forward. In the first, it's maybe banal, but I think, the judicial system, courts actually, are a very effective tool of implementing public policies. Very effective, actually are very efficient more than effective. Because courts can exploit what has been defined as their triadic logic, the logic according to which a third is intervening in a dispute and is solving the dispute by his or her intervention. I think this is very important. It's a mechanism, a social mechanism, which has been exploited, very often in different contexts, which is at the heart of the adjudication. In fact, it's an efficient because it tries to assure a resolution of the dispute without the employment of too many resources. In fact, in the case of adjudication, there is a third which is intervene, and the intervention by a third, it's focused on trying to achieve the consensus of the parties toward the judicial decision, even if the judicial decision is a negative decision for the part. No, this is a very important element, and we have to realize that actually the adjudication, the logic of adjudication, remain very much based on the fact that, the third will present himself or herself as a third, and will be able to discharge his decision, or being better, to base his or her decision on some legal rules, some previous legal rules. This point we are going back even later. Anyway, even from the historical point of view, courts have played a very important role in the process of political centralization of several states. The case of the United States is very well known, for example, in supporting the unification of the national economic market, or implementing civil rights. And a similar role has been played in the past by French and English courts in the process of state building. This is something which is very known. Anyway, there is another element which has to be taken into account in order to understand the success, the role of national courts in the building of the European Union. And the fact that, the European Union is a system of government which is devoid of a large administrative apparatus in charge of implementing its decision. And so it has to depend much on national structure, and especially on national courts. So national courts can offer the European Union with a very important asset, because they are, at least in principle, independent from national political institutions. I will say even something more. National courts have a kind of institutional interest in attaching themselves to the European Union, because in this way they can find a powerful ally, and therefore further strengthen their independence against national political institutions. So there is, if you want, a kind of logic of mutual support between the European Union and national courts. So, at least in principle, we are not to be surprised by seeing that, the European Union and national courts have a powerful institutional interest in supporting each other and informing, and supporting in the development of the supranational judiciary, or the European supranational judiciary, as we saw. However, this is the first part, then we have the however, on the other hand, if you want. The European supranational judiciary, it's a rather complex phenomenon, of course. It's composed mainly on national courts, not just of the European courts, but on national courts and national judges who are actually staffing those courts. And more, national units are not directly related to each other, except through the European Court of Justice in Luxembourg, And moreover, this is a very point on which I will try to deal, national courts and national judges are rather different from a structural point of view. They are not unified. They present some interesting, important difference. The point is not that the structure of national judicial system is different. The problem is that also national judiciary, national judges are different. And since we are dealing here especially with judicial culture, we will deal mainly with national judges. And I will put forward some elements of difference between, the different judiciary of the European, of the member state of the European Union. Just to give you some elements. First of all, national judges are recruited in a different way. They are chosen in a different way. We have competitive examination just after university or after a period of referendariat, a common training, for example, in German and Scandinavian countries, or sometimes with a more or less direct form of appointment from the bar, directly from the bar. And there is a degree of opening toward the bar and society, which is going to vary depending on the case we are dealing with, And so, above all, there is a difference to the extent to which judges are socialized outside the judiciary, and this is something which has some implication for judicial propensities, and this is an element we have. So first of all, recruitment is different. And recruitment is different, and also training is different. You know, maybe we are going to discuss it later. I see there are a couple of speech, intervention on this point. But actually, the training, in principle, at least, is different. Or it can be made mainly at university, or it can be in a post-university phase, maybe in a referendariat we just mentioned, or, and today this is, you know, an option which has increasingly got favor, and a specialized structure like a judicial school or a training center. And then also there is, you know, in the so-called, in the common law countries, situation in which judges are still training mainly at the bar, just before entering the court. So we have also here important difference. Then there are, judges also differ according to degree and type of external independence. Now, you know, I don't think I have to deal very much on the difference between external and internal independence. I think all of you know. But, you know, even from this point of view, there are still some difference inside the European Union. No? You know, for example, they are still under some influence by the Ministry of Justice, as it was once the case in most continental European countries. And in this case, in which ways and to what extent is this influence exerted? Or they are under the influence of political institutions, for example, Parliament appointing judges or maybe Supreme Court judges? Or rather, is their status administered by, I say, a relatively new institution, the judicial councils, in which judges are represented to some extent, more or less represented. So we have also, from the point of view of external independence, we have some difference inside the European Union, not to discard. Last, but not the least, just to play, European judges differ also according to the degree of internal independence. You know, this is not the point, you know, to the extent of which, you know, power, you know, the high-ranking judges enjoy powers in the management of the court. Even from this point of view, there are important difference. So if we take these four dimensions together, we can, you know, figure out, you know, some types of judiciary in the European Union. Just I simplify a bit. I think there are more or less four types. It's just a suggestion. I don't maintain it. It's a perfect typology. It's just, you know, very tentative. First type, very easy. This is the common law. Still in UK and Ireland, we still have judges recruited among experienced lawyers, training mainly inside the legal profession. They enjoy relatively high internal independence, and also the external independence has increased, especially in the last 10, 15 years. I think about the 2005 constitutional reform in the UK. This is, you know, the traditional common law types. Then when you go to the European continent, there are still three types of judiciary, we say. The first is the German Scandinavian, if you want. You know, judges are recruited in the traditional bureaucratic way through competitive examination, just after, you know, a training made together with the other legal profession, the referendariat we have already spoken about. They are still under some hierarchical influence and also of political influence. Sometimes, you know, Supreme Court's judges are appointed by the government or by parliament. This is the case of Sweden, also Germany to some extent, you know. And, you know, there is some influence on political influence on those on judicial appointment. This is Germany, Austria, Netherlands to some extent, and, you know, the Nordic countries resemble more or less this. Then we have the Latin type, you know, which is slightly different because, of course, still initial recruitment is the traditional bureaucratic, you know, competitive examination. However, just, you know, carry out just after university studies. However, this tradition is increasingly supplemented by judicial training by specialized structure, by judicial schools. Judicial schools are, you know, of course, now almost they are on the field since the late 50s, you know, but now it's one of the success stories of judicial training in Europe. And so, on one hand, we have, you know, judicial schools. On the other hand, traditional hierarchical structure has been reformed, and self-government, or some form of self-government, has expanded thanks to the institution of judicial council, more or less representative judicial council. This is the third type. And then we have the other the fourth type, which is the former communist, I think still they have some kind of distinctiveness. Judiciaries here are generally modeled according to the civil law type of the German or Latin varieties. However, they still tend to present a stronger influence by political institutions, especially by parliament. It's very much diffused, the fact that, parliament is appointing judge, for that. Recently, however, especially in connection with the accession to the European Union, these countries seem to evolve towards stronger guarantees of external and also, to some extent, internal independence. And so we have already a rather complex, landscape. At least 4 types of judges. We say 4 types of judges characterized by a very different institutional organizational setting. So it's already a hint that the EU supranational judiciary is to some extent fragmented or maybe pluralistic, as you like, even from an organizational point of view. I'm not talking about judicial decision, about judicial policy. This is not the story. But this. However, if we go to try to look to the policies, of course, it's a more complex field. I wasn't able to carry out a comprehensive research on judicial policies in all 28 states. But anyway, there are different contributions by different scholars that think that actually, the way national courts implement EU policies is rather diverse. For example, Bobek thinks that resistance to the jurisprudence by the European Court of Justice is more widespread than one would think, and other, there are discussion from this point of view, different points of view. But I think most of lawyers also think that actually the way national courts are implementing EU policies is rather different from one country to another one. Anyway, but the problem, I think, is very well known, and several efforts has been put forward in order to address this, even by the European Union. I think, it seems to me that, the prevailing policies, which has been designed in order to address this problem of diversity, of difference, has been, there are 2 types of policy. One institutional, aiming at, adopting and diffusing a common institutional setting of European judiciary. Try to homogenize, to some extent, the organizational and institutional setting of the judiciary. And the other, it's actually the effort at stimulating a kind of common judicial culture, supportive of the implementation of European policies. First of all, we say something very shortly about, the reform institutional setting, because this reform has been to some extent made on, following, the policies put forward by the Council of Europe. Actually, I think, from this point of view, the Council of Europe has made a lot of work. I'm referring especially to the recommendation of 2010 recommendation on judicial independence, which has to be to some extent received by all European states, to some extent at least. There are all other organizations working on this field. But, recently also the role of the European Union has increased. For example, we have to emphasize the role played by the European Network of Council of the Judiciary, which is a European and not a Council of Europe network, and it's pushing on that direction. The prevailing policy in this field seems to have been, the reinforcement, the strengthening of judicial independence. Of course, in order to gain the support of national judges and further reduce the influence of national political institutions. This is, of course, it's coherent with that, convergence of interests we have seen typical of the relation between the European Union and the national courts and national judges. However, the increase in judicial independence has not only the consequence of increasing the independence of judges from national political institutions, especially when also internal independence is involved, and this is very much often the case. In this case, it's one of the consequences is an increase of the general autonomy of judges, and in this way, likely also the inhomogeneity of judicial decision. And I would like to quote you, you know, something from the 2010 recommendation of the Council of Europe, you know, about judicial independence. The definition is very widespread, you know. In their decision-making, judges should be independent and impartial and able to act without any restriction, improper influence, pressure, threat of interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is a very important point, I think. The implication have to be put upon. Okay, so I think, however, the policy to support and spread a common judicial culture, it's related to this fact. By introducing more independence, you risk to have, you know, an increase in differences between, not just between courts, national courts, but inside a national a judicial system. So maybe the effort at building a common culture is a way to counteract this trend. Of course, the pursuit toward a common judicial culture is carried through several initiatives, like the European Judicial Training Network, and we have a speech later by Simone Benvenuti, very interesting from this point of view, and also the increasing role of judicial networks. You know, this is a way to diffuse, they have a socializing impact. You know, the idea is try to diffuse, to build up some kind of common culture. You know, anyway, it has been stated, if I remember well, and yeah, I quote something from an article by Monica Klaes, I think. You know, it's a judicial networks can and do provide a missing link in the European judicial system, linking national courts with one another. In addition, they can contribute to improving the interaction between European courts and their national counterparts. It is very clear the object of this, the policy, the cultural policy, if you want. So at this point, I've tried to, you know, to give you some hints about the extent to which this effort is successful. It can be successful, of course. And of course, these are just, you know, a very tentative answer. I did it in part for my curiosity and part for answering, you know, the proposal by Roberto Toniatti. And I will go later to talk about culture. And first of all, we have to make a short distinction between the legal culture and the judicial culture. It's very easy. It's very understandable, you know. You know, the legal culture, it's normally that set of cognitive and evaluative models of the law and the legal system exhibited by a specific set of people, usually those living in a specific society or political system. We talk about Italian legal culture. Anyway, this is just... Of course, we can further distinguish, according to Lawrence Friedman, this is just a very old sociology of law, distinguish between internal and external legal culture. You know? The internal legal culture is the culture of those performing roles in the legal system. You know, sometimes these people are defined as the legal complex, you know, people working, you know, judges, lawyers, you know, administrators, everything, I mean, public prosecutors. These are, you know, the legal complex, you know. The culture of this set of people is the internal legal culture. Then you have the, you know, external legal culture. It's the legal culture concerning the legal culture of the public, how the public is looking to the legal system, you know, the attitudes, beliefs, and values regarding the legal system by the public. So the judicial culture is part of the internal legal culture, is the legal culture of judges. This is I think very clear and very simple, but I think it's important. The external legal culture plays an indirect and important role in the legal system. In fact, it's likely to filter inside the internal side of the system, influencing in some way the culture of the legal complex. But above all, it's important because by influencing the behavior of the public in legal matters, it directly affects the functioning of the legal system. For example, just to give you, the external legal culture cannot but condition the degree of acceptance of judicial decisions by the parties. In this way, for example, it's likely to influence the behavior of judges and also the very rules judicial proceedings tend to adopt. For example, you know, judicial culture is very likely to influence the appeal rate, you know, the propensity of the parties to appeal a decision by a judge. And these are, of course, very important implications for the functioning of the judicial system. And we are lucky from this point of view because thanks to the Eurobarometer, we have today some good data about the legal culture, the external legal culture of the European Union. And, also data regarding the attitudes toward the legal system prevailing in the countries of the European Union. Of course, I don't want to bore you about the limits of survey data. Survey data are always, they have always to be taken with extreme care, but we do. It's a tentative. I told you I don't pretend to find out, the truth from this point of view. So I think they show, and now I have also something. Ecco. Fine, I found this. These are the data of the last two Eurobarometers, sorry. It's 2013 and 2015. I just find out, the trust by people on the national courts and the European Court of Justice. And this, you have the data, and the delta is the difference between the two data. I think, it's very interesting because you see that public attitudes toward courts vary. And they seem to mirror the different types of judiciary we have discovered just a few minutes ago. I show you this. Sorry? Okay, I just made the something we do always in very simple in the social science. We cross. This is a bit rough. I put forward. It's a bit rough. It's above. Above average and below average, and then you find that there are 4 clear types of legal culture in the European Union. The German Nordic, characterized by high trust, both toward national courts and European Court of Justice. The common law, with high trust toward national courts and low trust toward the European Court of Justice. Not surprising, I think, but this is just, Then we have the former communist, with low national trust, but high trust toward the European Union. And then we have the Latin. They are very low, both toward everything, national and European. This is very, of course, it's rough, but I found, exhilarating, I would say, this result. Anyway. So it's interesting that, there is a continuity between a relationship between, the types of judiciaries and the types of legal culture. Okay, but it's the legal culture, it's external legal culture, which is rather different. I was trying to do something also on judicial culture, the culture on the internal internal legal culture of judges. I didn't find any systematic surveys of judicial attitudes in Europe. There are some, but I wasn't able to find out, even because it's a very, very difficult enterprise, And especially, there are some studies, of course, looking in a couple of countries in which there are some, scholars, emphasizing the difference between one country and another country. There are several very interesting. Most signal different approaches to judicial decisions, especially difference in the way they take into account the European versus the national sources of law. There is some difference inside, But anyway, it's impossible, at least for me, I wasn't able to present a detailed analysis of the traits of the culture of the European national judiciaries. However, I did some tentative work even in this area, and I tried to infer some cultural traits from some behavioral trends, and more precisely, from the data I found, from the propensity by national court to ask the European Court of Justice for a preliminary ruling, a trait that can be associated with a judicial culture more open to European Union influence. I just come in a few minutes. And the second element is from the extent to which these referrals are produced only by the highest court or also by the entire corp. A sign of the diffusion of the openness toward the EU. It's a tentative. You can discuss it anyway. And we look to the result. These are references per million inhabitants. I only calculate the last 10 years in order to discount to some extent, but this can be discussed you know, the fact that, you know, the former communist countries entered after 2004, the exception of Croatia. You know, there are some countries with a very few cases, actually, and so I can, in my paper, there are also some notes about, you know, the cases, the countries in which there are so many cases that they are not significant. But, you know, and, you know, what is more interesting is this. This is more interesting. Actually, you know, this is the percentage of the referral coming from the lower. It's a tentative effort. I put forward, I try to ask for mercy, because it's a bit, you know, there is some simplification. It's likely that the results could be influenced by some institutional organizational trait. We have to think about the organization of the judicial system can have an impact on that, of course. However, taking as a point of reference the previous classification, the following trends seem to emerge. In common law countries, and especially in the case of the UK, the propensity of courts to ask the European Court of Justice seems to be rather low, and this attitude seems widespread, which is maybe understandable. German and Nordic countries, on the other hand, show all a strong propensity to send referrals to the European Court of Justice. In some cases, Netherlands and Finland, this propensity depends a lot on the strong role played by the highest court. I think this can be investigated. Maybe there is something in the structure of the judicial system explaining this. Anyway, the Latin area this time is split between Italy, with high propensity for referrals, and Spain and France, and also to some extent Portugal, less willing to address the European Court of Justice. In all these countries, referrals seem to come from all sorts of courts, especially in Italy, from what I understand. Yes, and Spain, also Spain. In former communist countries, the trends seem to be toward an increase in referrals. However, Hungary and also Latvia, Bulgaria, and Lithuania show more propensity to send referrals. And, you know, as for the role of lower courts, it seems stronger in Bulgaria and Hungary. Of course, as you can see, the data show a very complex landscape, very difficult, very different, you know, attitude by national courts toward the European courts. You know, it's you know, to some extent, which is very interesting. You know, national courts not behave in the same way in this matter. You know. So from this, if we take this element as with all the care I have emphasized, we can say that national judicial culture so far seems still rather divergent, mirroring to some extent the differences in external legal culture and in the structure of the judiciary. So it's, of course, you know, more national courts, therefore, are likely to be conditioned by the organizational and institutional setting of the national judicial system. Of course, this is just, you know, tentative explanation. Okay, just to conclude at this point. You know, the scenario, the situation seems to be characterized still by significant differences among national legal and judicial culture. And, you know, a common judicial culture seems still to emerge. Maybe time is significant and much is likely to depend on the general progress of the European Union design project. And, of course, the quest by the toward the European judicial culture is understandable because, as I emphasized before, it's an important element in supporting the implementation of European Union policies. However, just to conclude my speech, I think there is another important element to take into consideration. The judicial culture must deal in some way with the relationship between the judge and the law, the judge and the legal rules, and therefore with the problem of judicial legitimation, because the legitimation of the judicial decision is very much depending on the image of the third, on judicial impartiality, and the fact that the decision is based or can be present are based on previous legal rules. You know, judges tend to legitimize their role by recurring to their qualities, professional quality, impartiality, and above all, as I told you, to the fact that their decisions are based on the law. Today, the problem is that the complexity of the legal system introduces a risk. it is more and more likely that also judges do not really know what the law is. Just to remind Chief Justice Hughes, who was saying that the Constitution is what the judges say it is, and maybe today we are in a situation in which, judges sometimes they don't know what it is. But some certainty, it's necessary for their very legitimation and effectiveness. It's a problem of, I would say, not so much a problem from a legal point of view, of course it is, this is not my job, it's a problem from the functional empirical point of view. So this is an element. The effort at building a common European judicial culture aims also at closing the gap. It's difficult to carry out, but the effort has a lot of merits. However, and this I may just put an element to end my speech, judicial legitimation and especially the definition of what the law is cannot be based only on the judicial culture, but I think must get the broader support of the legal complex, broader legal culture, and also to some extent of society at large. Because pursuing only the development of a judicial culture, disconnect from an environment, carries the risk of isolating in an excessive way the courts, and at the end to weaken the position of the judiciary. I think from this point of view, empirical research has shown that the capacity of courts to perform their role in an efficient, independent way depends very much on the support of the public. Without the support of the public, judicial independence, it's from the behavioral point of view, not from the legal institutional point of view. Judicial independence from the behavioral point of view can be put at risk. And so the problem of judicial culture is important. I agree with this completely, but it's also important that judicial culture will not be disconnected from the legal culture and from the culture of society at large. Thank you very much.
Thank you very much to Professor Carlo Guarneri. I think his presentation provides us with a very, I would say, very rich landscape for situating our reflections and our analysis on the supranational judiciary. While I was listening to him, I had the perception at a certain point that we could be in a situation in which, after having studied the variety of capitalism in the European Union, now we have the varieties of legal cultures, but this is just a speculative element that I just put forward without an in-depth reflection. And then there are a number of ingredients that I think will enrich our discussion in the later sessions of the conference. There are a number of dichotomies, the dichotomy between the diversity as a reflection of legal cultures and judicial independence, but also efforts by international and supranational organizations to provide homogeneity and coordination. Then another dichotomy, the resistance on the one hand or recalcitrance of certain judges and certain courts, and the efforts at networking and coordination. And beyond this, the profound problem of legitimacy and the problem of connecting the judicial and the legal culture in which courts operate, and the fact of whether we can think that it is possible to develop a supranational legal culture accompanying the working of the supranational judiciary. So I think we have the landscape, we have the ingredients. Perhaps now we have the possibility also of linking some of these points in a discussion more centered on the functions and the role and the legitimacy of the supranational judiciary. Professor Maduro, thank you.
Thank you very much. So when Roberto contacted me to invite me to come and speak at this conference, I told him that I've been away from academic life and law for 3 years, but that this will be, in fact, having returned a few weeks ago, that this might be a good opportunity actually for me to smoothly get back into the academic and the legal world. And I thought particularly so because the topic of the characteristics of the supranational judiciary is one I know well and I'm very much interested, but also because of the link made with pluralism and particularly with constitutional pluralism. But I've also told Roberto that I wasn't going to be in a position to deliver a paper, and therefore we agree I was going to do concluding remarks. It happens that because of my own agenda that requires me to be back in Florence today, the concluding remarks turned into introductory remarks. And having read, nevertheless, in order to prepare these remarks, some of the outlines of the papers, what I thought was going to be a celebration of constitutional pluralism, having read the papers, turns in many cases into a strong challenge into constitutional theorism, a theory in which I work. So one leaves academia and the law to return 3 years back and see that the theory in which we have been working is being dismantled. What I thought was a smooth and welcome introduction back into the academic world turns into a more challenging one. But I say this in a very positive and welcoming way because most of the papers are still, that I got, still introduction, outlines, but some of the points that are there I think are important points. So the way I decided to make basically 3 points is by having one broad point that is of organizational character, and that looks at the role and the organization of the supranational judiciary in a different way than the ones traditionally looked at. And then I'll make 2 more briefer points addressing normative questions that are raised, particularly in papers that challenge constitutional pluralism and particularly challenge the potential that constitutional pluralism may still have as the appropriate way to both conceive and regulate the relationship between the European courts and national courts. So my first point departs from an understanding that I've always had that somehow we misconstruct the role of courts in general, and that this misconstruction is particularly, in my view, particularly strong and negative with respect to supranational judiciary. Why do I mean this? We tend to talk about courts and the interpretation of the law as being the exclusive domain of courts. The idea is that courts control how the law is interpreted. What is the right interpretation of the law, and therefore what is the law, in fact, is a product of courts. In my view, and this is the point I would like to make, and then to draw conclusions on the role and the organization of the supranational judiciary, the interpretation of the law is, in fact, a product of a broader judicial discourse. And this does not necessarily have to do with endorsing constitutional pluralism. That is, even whatever our view on the value of constitutional pluralism, law, but particularly EU law, is a product of the interaction between national and EU courts. This is the price of the European Court of Justice success that Professor Guarneri was mentioning. This means that the development and the interpretation of EU law is at least in part a function of or dependent upon national courts and national litigants. They set up the agenda for the European Court of Justice. I used to say when I was at the court that many times the court was being labeled as the engine of European integration, but an engine without fuel doesn't work. And the fuel of the European Court of Justice were national courts, were litigants bringing to the case. And by bringing the case, they will shape the agenda. I could tell you exactly, including Mr. Bosman was a very good example, but many others. But there are many instances in my life when I was at the court that I will see something and say, oh, this will be a fantastic case. This is a clear violation of EU law. but I couldn't do anything, even if I was a member of the court. If no one will brought the case, we couldn't do anything about it. But then, it's not only the fact of setting the agenda, is that the way they make use of EU law, because EU law is then applied, implemented in a decentralized way. They take over, they take ownership of the decisions of the European Court of Justice and the interpretation it provides, and then give it meaning in specific cases at national level. And this means, therefore, that what EU law is, what the interpretation of EU law is not the exclusive property of the European Court of Justice or the European courts, including the General Court. The rules, decisions, and particularly the interpretations given are a product, are a result of the agenda set by litigations, and the way the decisions taken by the European courts are then taken over and used by a much broader legal community. We could say, if you forgive me the parallel, that, and in this respect, the European courts are a more extreme case, or something that, in my view, happens in any legal system, that the final allocation of judicial and legal resources, and as a consequence of that, the final determination of the law, is determined by the supply and demand for justice. Judicial decisions do not single-handedly determine and command the meaning of law or command the use of law, but are determined and subject to the interaction with the other actors. This is particularly relevant in the context of the European Union legal order because of its decentralized character. Its decentralized character provides much more empowerment to national actors, to a different set of actors. Of course, if one endorses constitutional pluralism, theories of constitutional pluralism, and I'll get to this in a moment, this discursive character of the law assumes a particular nature and requires courts to behave in a particular way. That is, if one accepts constitutional pluralism and its normative consequences, it means that courts need to engage in this discourse in accordance with a particular set of rules. I've developed this in previous work. This has consequences as to the role of the European Court of Justice and what the European Court of Justice controls and does. The ECJ, in fact, does not control demand, but it controls supply. But this supply is, in turn, a function of the institutional characteristics of the European Court of Justice, its practices of judicial deliberation and judicial reasoning, and the way it reacts to the political, economic, and social context in which it operates. It is these elements that allow us to identify what are, and this is the work that I would like to claim it's necessary to be done, that allow us to start developing a conception of what are the variables that determine the supply. That is, that determine when is the European Court of Justice more willing to intervene or not intervene? When is the European Court of Justice more open to incentivate litigation in an area of the law or not? And in the second moment, I will explain what are the instruments through which the court actually does this, through which the court provides either negative or positive incentives for litigation in a certain area of the law, decentralizes or centralizes certain forms of definition of the law. But the first point is to determine what are the variables, what are the elements that explains why the Court of Justice in some areas appears particularly eager to intervene and in others appears particularly eager to be differential or not to intervene or to delegate on national courts. The first is judicial resources, the area of workload management. And it is important indeed, let me tell you, having been at the court. The perception that whether if you decide in one way, you might lead to an overwhelming number of cases that will dominate and overload your docket is very relevant and plays. Even if courts do not explicitly articulate it, it plays a role on how courts decides. So This is therefore depends on the number of judges, the role and number of advocate generals, the existence or not of oral hearings, translation costs that are extremely relevant in the European Court of Justice, lengths, very practical things such as the lengths of party submissions that in a court that depends on translation becomes even more relevant. All these very practical details are extremely relevant in determining workload management, and therefore how the court makes uses of its limited resources. The biggest constraint on a court, it's its resources, decisional resources, and often is a very strong determinant on what a court decides to do or not to do. The second variable, it's the character of deliberation that may lead towards judicial minimalism or to more clarity or less clarity, and with that additional, with more or less clarity corresponding to less than demand or more demand. The more clear a court is, the more it reduces the pressures in terms of demand. The more unclear it is, the more demand it will tend to stimulate. And this is very relevant in terms of the European Court of Justice because of its consensus pool. The European Court of Justice is a court that works under the paradigm of consensus in judicial deliberation. For several reasons, but mostly, I would say the most important of all, is the absence of dissenting opinions. With the additional consequence in the European Court of Justice that a reporting judge, that is the judge drafting the judgment, may have to write a judgment against his or her opinion on the case, because the Court of Justice doesn't even change the reporting judge, even if the reporting judge does not favor the majority view. And in fact, what happens is that very rarely there is a voting in the Court of Justice among the chamber deliberating on the case. There's a pull towards consensus. The idea that, okay, if you're going to decide that way, at least don't say this, or at least add this sentence. And of course, the consequence of this is that often you agree on a minimum common denominator, and this explains very much the reasoning in a lot of judgments of the European Court of Justice. Or in other instances, you have what appear to be contradictory sentences in the same judgment. And often what explains that is because it was a way to accommodate the minority view of some judges in the case. And so there was a sentence to reflect their point of view on the case. Of course, therefore, this character of deliberation, its impact on the reasoning and the motivation of judgments and justification of judgments of the European Court of Justice, then has an impact on how those judgments are going to shape whether the Court of Justice is going to induce more or less demand. A third variable is what we could call legitimacy management. That is, it's not necessary that the court, any court, responds to social and political pressure per se, but it is no doubt that any court is aware of the economic, political, and social consequences of its decisions. And I will argue that, in fact, the law requires courts to be aware of that. An integrated, holistic approach to interpreting and deciding the law on the part of courts must require courts, in order even to make sense of that individual judicial decision into the broader principles of its legal order, to incorporate the political and economic and social consequences of all they decide. And of course, this is a matter of institutional choice, then, of how the court sees its role regarding that of other institutions, such as the political process, or European courts versus national courts, and the way then the courts manage the legitimacy and the impact of its decisions. And any court has, as I used to say to the people working in my chambers when I was Advocate General at the court, or to my referendars, I used to tell them, every one of them coming to work with me, we have a number of credits every year for innovating. Let's make good use of it. We can't innovate all the time, because if we do, we lose credibility. So we need to choose well where we want to push the law in a certain direction and where we believe we don't need. And the court is a similar thing. There I was just reflecting, in fact, what the court as an institution does. Whether it goes far enough, it doesn't go far enough, that's another question, but courts do that. A fourth element is individual case dynamics. That has become very relevant, very visible to me while being at the court. The pressures for substantive justice in a particular case are much more relevant than we normally tend to articulate when we discuss the role of courts. There are many instances where really you see a case, you see, if you want, an injustice, something that needs, but on the other hand, you realize that in order to answer to that, to provide the answer that you believe is correct in terms of the justice required in that case, as a trade-off in terms of the risks of the systemic impact of that decision. And the way courts and the European Court of Justice maneuvers through that is one of the most sensitive and difficult aspects. But you see that in many cases. A tension between the decision that wants to be taken in that individual case and the risk of the systemic consequences. And this impacts, for example, the reasoning of the court and the way it is put forward. 3 further notes of a general nature on these 4 variables that I will identify: judicial resources, character of deliberation, legitimacy management, individual case dynamics. The first note is that these variables may not always pull in the same direction. So, more judges increase the capacity in terms of output of the European Court of Justice. With more judges, the court can decide more cases and can decide faster. But on the other hand, reduce its collegiality. And by reducing its collegiality, it might also make the reasoning of the court more unclear, and as a consequence, induce more cases and bring more workload on the court. So one important point to have in mind is that these variables do not always work in the same direction. The second is that the European Court of Justice is subject to an additional difficulty on the way it relates and manages its supply of justice with respect to the national courts. And this is very much follows the very interesting remarks done by Professor Guarneri. And it's basically the point that the European Union legal order is an asymmetric legal order. It's not only decentralized, it's asymmetric. Because the way the different national legal orders and the different national judiciaries know and relate to the European legal order is substantially different. And this means, as you could see by the number of references, and I had made a study similar to that and a statistical analysis, and the conclusions were very similar. Perhaps the UK was the only one that I was surprised to see with such a low number, but I think of references per capita. But I think if you introduce the variable of the number of cases in the judicial system, the UK goes up. Because the UK, one of the elements that explains it, that in general, I think they don't have much litigation reaching courts. But in relative terms to the number of litigation, they probably will be higher. It may also be that in the recent years, the UK has in fact started to refer less, and that will be interesting to look at in terms of a timeline, how the UK has evolved in that respect. But the point I wanted to make in here, and for that respect, the statistics and the remarks presented by Professor Guarneri fully fit in this respect, is this one. The European Court of Justice is faced with an asymmetric legal order. And this is very relevant because the admissibility criteria, the court needs to have one admissibility criteria. But for example, the same criteria being more or less tolerant to the quality in terms of the clarity, the elements necessary in terms of admissibility of a case brought by a national court, the same criteria may be too demanding for a national judiciary that's still not used to EU law or is very resistant to EU law, and therefore you want to incentivize to bring cases, and actually, on the contrary, be too broad, too lax, with respect to national judiciaries that are very much accustomed, prepared in general to use EU law. So this is a point I would like to make, because often when I see remarks on whether the Court of Justice is in terms of admissibility, for example, in using the right or wrong criteria, one doesn't take into account this circumstance, that what may be right in the relationship with the national judiciary may be wrong in the relationship with another national judiciary, but the court somehow has to find a way that is one decision, in terms of uniform application of EU law, that work well for stages of integration of and relation of national judiciaries with European legal order that are very different. And so this is a strong difficulty for the court. The third final point in this respect that I wanted to make is that the importance, and that's why I stress the need to do more work on this kind of analysis, the importance of it is that it's necessary for the management of supply of justice that is done by courts to be determined by normative criteria and not opportunistic or arbitrary reasons. And in fact, I will argue often the supply of justice by courts, that is, the willingness or not of courts to intervene in particular areas of the law, is not by lack of sufficient work, theorization of this area, is not a product of a normative choices of courts. It's a product of the day-to-day working of courts. And you work in some way, and there's a period when the court is overloaded, and suddenly the court becomes much more restrictive. And then there's another period, another area where it becomes much more lax. So it's very important to theorize, to work, to conceptualize this aspect of the law in order to allow courts to do this, if you want, in an informed and normatively correct way. So, and what are then the elements that courts, and particularly in this instance, the European Court of Justice, use to regulate supply? So far I've talked about the variables that determine when the court is more willing or less willing to intervene. What are the instruments that then the court uses to show its willingness to intervene or not? There's a variety of them, many, I would say. And many of these are similar to what you see at national level. First is what I would call filters. Admissibility is a clear element. The necessity, in terms of EU law, the necessity of the answer to be provided to the national court. One sees this, for example, the Bosman case that you were mentioning. One of the questions that the European Court of Justice decided on the Bosman case was not necessary for the decision of the judge at quo, of the national judge in that case, was the national quotas. Because in that French club in which Mr. Bosman wanted to play, there were no other non-French football players, and so that was not the reason why he could not be hired by the Dunkirk. If I remember correctly, it was the Dunkirk, the French club. So that was not necessary. And in many other instances, the court has said, well, it's the question the national court poses us is an hypothetical question, therefore, we are not going to answer it. In that instance, the court answers it. And you find the reason if you read the opinion of Advocate General Lenz, because he alerts the court to the fact that if the court will not decide that issue, in that case, it will not very likely have another opportunity to decide that legal issue. And the reason is simple. Mr. Bosman, that became famous in law, for all of us in law, didn't become famous in football. In football, there was another famous Bosman, but not that Bosman. The reason was not only the one I'm going to say, because even his football potential was not extremely high, but nevertheless, in his final 3 years of his career, he didn't play. Remember that. Until the case was finally decided by the European Court of Justice, it was 3 years without playing. So what Lenz was saying to the court is, these cases brought by sports people, they're very unlikely to come to the court, because who is willing to be 3 years without playing in the expectation that then the European Court of Justice in the final instance, and then the national courts applying, will tell them that they are right? Very limited. It was a fluke, like you say, that the Bosman ever arrived to the European Court of Justice and the Court of Justice was able to decide that. And that it was because of that the court realized, well, let's be lax and be very open. And you see that in many cases. When the court realizes that's an opportunity it wants to seize, suddenly it relaxes the admissibility criteria. When in fact it doesn't want to decide, then the admissibility criteria becomes stricter. And the necessity of the answer is one element that the court uses, but there are other elements of that. The scope of EU rules is also used in that way. The concept of purely internal situations. Sometimes you are required to be more purely internal than in other circumstances in order to have the case excluded from the court deciding it. This is all a series of criteria. Or the choice of the legal question. The court almost always decides first the admissibility question, it is a procedural, and then the substantive question. I had a very interesting case that was a case involving Poland. And it was, Poland wanted to challenge a regulation on the common organization of the agricultural market between the period when it had signed the accession agreement and the period that it had become a member. And it was somehow, that would fall in a vacuum and it couldn't have standing as a member state to challenge. But the risk was that will put accession member states during that period in a position where they wouldn't be fully protected, because as it had happened, the Council had adopted a regulation, and this regulation, Poland was claiming, affected its rights as a member state that still wasn't, but was going to be when the regulation was adopted. But this was a really difficult question from the point of view of standing, and a very principled question, but the procedural one. Actually, the substantive question, whether the regulation in the common agricultural market was in fact violating the rights of Poland in terms of equal treatment to the other member states, was, in my view, and the court agreed, easy, and Poland wasn't right. And I decided both questions, and in the procedural one, the admissibility that I started by deciding, I argued that under the general principle of judicial protection, that Poland should be entitled to have a more lax interpretation of the admissibility and its standing to challenge the regulation as an accessing member state after signing the treaty, but before being a full member state. But since this was such a difficult question, and perhaps because the court couldn't agree on it, if you read the judgment, you see something that you almost never see in a judgment of the court. The court starts by saying, well, there is this admissibility question, and then there is this substantive question. Let's start by deciding the substantive question before the admissibility question. Decides the substantive question and says, because in substance, in any event, Poland is not right, there's no need to decide whether or not it could bring the case in the first instance. It was an extraordinary way for the court to avoid deciding a question that was the most difficult, and in which I suspect, and that is without violating the secret of deliberation of the European Court of Justice, because the Advocate General didn't participate in that deliberation, I suspect that most likely the court couldn't agree on what was the line to take, and therefore the way it was found out was, well, let's decide on that and leave that question aside. One other instrument the court has is the interpretation of SILFIT, that varies. And SILFIT is basically an instrument through which the court regulates decentralization to national courts, including, for example, how the court varies the way it interprets the distinction between interpretation of EU law that belongs to the Supreme Court of Justice and application that belongs to national courts. That fluctuates a lot, and it's an instrument, again, that the court uses. Judicial minimalism is an instrument that increasingly you might see in the European Court of Justice too, as an instrument to regulate supply. Variations between right and remedy, sometimes being strong on the right but then weak on the remedy, is something that courts use in general, and you also see at European Court of Justice. Corrective interpretation that is more than conform interpretation. Conform interpretation I would include under corrective interpretation, but corrective interpretation goes further than that, because one way you see it in the European Court of Justice is by often the court saying that the national law is not incompatible with EU law by choosing one among a variety of possible interpretations of national law that is put forward by the parties, and not necessarily the interpretation that is favored by the national court that has referred the question to the European Court of Justice. Proportionality and other open-ended legal criteria allows the court to regulate, both to delegate to other courts and graduate the degree of judicial decentralization, if you want, but also, in other instances, is used by the court to preserve, if you want, some judicial discretion in inverted commas for the future. The way the court frames the answers is another instrument, notably in Cassé de Dijon. Cassé de Dijon is perhaps a decision, one of the decisions that most limited the regulatory power of member states. But if you read the decision, it is drafted by the court as preserving the regulatory power of member states. The court says member states can regulate except if the... So the way it's drafted is to seem to be accommodating the needs of member states, when in fact the decision reverses the onus and strongly puts a possible limit on what courts can do. So the point I wanted to make is the importance that these elements, this conception of the law as the product of interaction between the European Court of Justice and national courts and litigants and other actors, is in determining what the law is, in determining the role that the European Court of Justice itself plays, in determining what the interpretation of EU law in the final instance is. And my claim in here, what I like to argue in here, is the importance to work on embodying all these elements into a coherent normative theory of supply and demand of justice, if you want. I think this is an area where the legal scholarship needs to do more work, and we haven't done sufficient work. I wanted to conclude with, as I said, with two more briefer points on, as a reaction to the outlines and draft papers that I read, at least those that I had the opportunity to read, and particularly on the challenges that they make to constitutional pluralism. Reading several of the outlines, it appears that indeed we're talking about and seeing the demise of constitutional pluralism. I think it's important, first of all, and this will be unfortunately not going to be in the nature of a concluding remarks, and I won't be able to be here tomorrow, but I think it will be important for those that are challenging constitutional pluralism to articulate more clearly exactly what they are challenging in terms of constitutional pluralism. In the past, I have argued that constitutional pluralism involves three claims. The first is an empirical claim. That is, this empirical claim is that constitutional pluralism is what best describes the current legal reality of competing constitutional claims of final authority among different legal orders and different courts, and the judicial attempts at accommodating them. Constitutional pluralism, and I want to make this clear, doesn't require for courts, in particular either the European Court of Justice or constitutional courts or high courts, to explicitly articulate constitutional pluralism. People working on constitutional pluralism never stated that they expected the courts to say, oh no, this is a constitutional pluralist relationship, or even to use the language of constitutional pluralism. But what constitutional pluralism argues is that the way that those two sets of courts, national courts on the one hand and European Court of Justice on the other hand, interpret their internal legal orders is such that or better, it's determined by the awareness that they are in a context of constitutional pluralism. That is, they redesign, reorganize their domestic legal order, their internal legal order, in order to accommodate the claims, the competing claims of the European legal order on the one hand or the national constitutional orders on the other hand. This is what constitutional pluralism argues. And it argues this, first of all, as I said, from an empirical point of view. The idea is that what best reflects the way national constitutional courts react to decisions of the European Court of Justice and vice versa is an attempt to accommodate these claims by redesigning, reorganizing their respective legal orders to try to accommodate and avoid conflicts. There are also, an additional, two normative claims in constitutional pluralism, in my view. And not all people that endorse constitutional pluralism endorse all these three claims that I'm putting forward. But in my view, my own vision of constitutional pluralism involves these three claims. The first normative thesis is that the question of final authority ought to be left open. So the empirical thesis is the question of final authority is open. And constitutional courts and the European Court of Justice, in their practice, aware of this, try to accommodate. The second, the normative thesis is it ought to remain open. Federico is there and doesn't agree, and I'm sure he will tell you why. This normative thesis implies or is supported or has a subtext, in fact, that those competing constitutional claims are of equal legitimacy, or at least cannot have their respective legitimacy claims balanced against each other in general terms. It is the fact that they are of equal value, that they cannot be balanced in general terms, that then justifies leaving the open question open. But a thicker normative claim, that I've also argued in the past, relates constitutional pluralism and constitutionalism in general. And this, in the thicker claim, the constitutional pluralism in the current state of affairs is what provides a better approximation to the ideals of constitutionalism than either national constitutionalism or a fully fledged European constitutionalism could offer at the moment. Now, I'm not going to get into here on, I've done this work and wrote about this in the past, about these different claims, but what I wanted to make clear is that I believe that even if there could be challenges to the two normative theses that I put forward, I think that there are no indications that empirically courts are abandoning constitutional pluralism. Maybe there is. As I said, I've also been away from the law in the recent terms, but I have no clear, in what I've read, even in the papers, no clear indications that courts are ready to clearly abandon the strategy of trying to accommodate their mutual claims. So, even if courts might not endorse constitutional pluralism in normative terms, strategically, they still seem to behave in light of constitutional pluralism. And therefore, the empirical thesis, in my view, there needs to be stronger evidence to challenge the empirical thesis. But I will make also a recommendation, actually, to those that are challenging constitutional pluralism. And it is that, in my view, if they want to succeed in challenging it, they need to provide courts, national courts, and the European Court of Justice too, with alternative strategies to deal with the consequences of abandoning pluralism. Maybe it may be even true, as a semester, that both constitutional pluralism is not normatively the best way to address and regulate the relationship between national courts and the European Court of Justice. Maybe it's even true that courts themselves at the European level, national level, don't want to normatively accept the idea of constitutional pluralism. But if they continue to behave in this way, to try to accommodate their mutual claims, I think the explanation must be because they fear the consequences of fully fledged conflict And they fear that the alternative to this form of judicial discourse leading to accommodation is not there, or will be worse. So if you want to be successful in challenging it, my recommendation will be come up with an alternative to courts on the consequences of what will happen if they will abandon it. My third and final point has also to do with what I've read in some of the outlines, and it has to do with the relationship between national courts and the European courts in the context of financial, economic, and political crisis of the European Union. There is an interesting parallel, and I just realized this actually recently, between the difficulties that the European Union has showed politically and economically in dealing with the crisis, and the initial challenge faced by the European Union legal order. The initial challenge of the European Union legal order, and it still exists, is latent, but that has been successfully, in my view, to a large extent, addressed. And this relates to what Professor Guarneri was also saying, was the need to develop a uniform, I prefer to use coherent, harmonized legal order in a context of pluralism, or, if you want, legal fragmentation. And constitutional pluralism, or the instruments that were developed, was a successful way through which we were, in fact, able to develop a coherent European Union legal order, even in such a context. The parallel with the challenges faced at the political and economic level by the European Union in the recent crisis, but that hasn't been answered successfully, is striking in my view. Because the reasons why the Union hasn't been able to effectively and successfully address the crisis is a difficulty to develop common policies in a context of political and economic fragmentation. The stronger, more important reason for the lack of effectiveness that in many respects the Union has shown in addressing the financial crisis, but also now the refugee crisis, is the difficulty on leading with political fragmentation, is the fact that you have to develop common European policies on the basis of different national political spaces. And these different national political spaces haven't internalized the consequences of interdependence, of European interdependence. Because they haven't internalized the consequences of this interdependence, they provide the wrong political incentives for the different national political systems, and you don't have a way to accommodate, to coordinate them, to arbitrate them at the European level. So it's this difficulty to coordinate and arbitrate different political, democratic spaces in developing common policies. So this difficulty of political fragmentation in the context of common policies that explains many of the difficulties that the Union has. Now, some of the papers, if I suspect, for example, Agustin's paper in the outline that wasn't clear to me, seem to trust on courts the role of trying to merge and deal with the difficulties posed by that political fragmentation. In fact, as I said, courts, the legal order, has been more successful in dealing with this than the political system. But in my view, that is not an argument to say that courts ought to replace the political process in trying to correct the difficulties arising from this political fragmentation. In my view, the risk of involving courts is that instead of courts providing harmonization in a context of political fragmentation, what may happen is that courts may instead become captured by fragmentation themselves. And what we may have is that the risks of what we see in terms of the difficulty of coordination of different national democratic systems, political spaces, being transferred and being replicated in the relationship between the different national legal orders and the European Union legal orders. The political fragmentation and conflicts might actually then extend itself to the legal domain. So I wanted to end with this word of caution on not transforming the success that, with all the difficulties we have had in having a coherent European legal order in the context of initial fragmentation, into excessive trust on courts and the law in solving the political fragmentation problem that the Union also solves. The consequence may actually be the exact opposite of what we might wish for. Thank you.
I think we can say that we are very grateful to Professor Maduro for this very rich presentation, and or I would say very provocative and forward-looking open remarks. I say forward-looking because he said that it depicted not only a portrait of the landscape we are facing, but also he gave us a research agenda that I think we have to consider if the work of this conference is going at a certain point to become something more substantial in terms of publication. So certainly certain of his insights will be taken up or at least thought upon. I think we can have now the coffee break, and I would suggest to be back at 4:40, so 20-25 minutes of maximum of a break, and afterwards we will start with the first session of the conference. Thank you.